Hello, and thank you for taking the time today to join us to learn more about the California Environmental Quality Act. My name is Crystal Rizzi, and I'm joined today by my colleague, Olivia Irvin. We are from M Group and have been retained by the city's planning department to present information that will help you better understand the CEQA process.
I'm Olivia Irvin. I'm a principal environmental planner with M Group. Our firm has been providing planning services to Bay Area communities for over 15 years. I graduated from UC Davis with a degree in environmental resource science and have been working as an environmental planner, assisting municipalities in compliance with the California Environmental Quality Act. My interest in this field is born from a desire to achieve a healthy balance between the natural and the built environments.
And as I mentioned, my name is Crystal, and I've been working with M Group for almost 7 years. Since 2018, I have served the city of San Rafael in several capacities, including staffing the public planning counter, processing development applications, and assisting the city with CEQA-related projects. I'm delighted to have the opportunity to be here today to provide information that will help increase your CEQA knowledge base. We'd like to start our presentation by providing an overview of the topics we will cover today. We will begin by outlining the purpose and intent of this workshop, followed by an overview of CEQA's history, applicability, recent changes, and will provide examples of the variety of CEQA projects you may encounter. Next, we will focus our discussion on environmental impact reports, including the process and procedures of preparing an EIR, the required contents of both the draft and final EIR, other topics for consideration, public comment opportunities, and the roles and responsibilities of the various agencies. The purpose and intent of this workshop is to increase understanding and awareness surrounding CEQA, equipping participants with the knowledge needed to understand CEQA's key principles and its role in the land use planning process. This workshop is also intended to develop the skills and tools needed to navigate the CEQA process, enhance decision-making, and promote transparency and collaboration between all stakeholders.
So let's dive in. We'll start with CEQA at a glance. We'll define CEQA and touch on its history. We'll talk about what it is and what it is not. When it applies, we will touch on some of the recent changes to the CEQA statute, and we'll provide a few examples of local activities in the city of San Rafael that would be subject to CEQA review and the different levels of environmental documents that may result from that process. Now that you've heard us say CEQA several times, some of you may be wondering, what is that four-letter word? CEQA is an acronym that stands for the California Environmental Quality Act. It refers to a body of legislation contained within the California Public Resource Code that institutes a statewide policy for environmental protection and compliance. CEQA was enacted by the state legislature in 1970 following the United States Congress's adoption of the National Environmental Policy Act, or NEPA, which applies to activities undertaken by federal agencies, while CEQA applies to activities under the purview of California state agencies, including cities and counties. Both NEPA and CEQA were established in response to growing concerns in the 1960s about the conditions of the environment. CEQA is intended to provide for a public process and inform decision makers and the public of the potential environmental effects of a proposed activity. CEQA is now over 50 years old and has evolved over the decades through direct changes to the legislator and is shaped by case law. The most comprehensive update to the CEQA guidelines occurred in 2018 and was prompted by the California Building Industry Association versus the Bay Area Air Quality Management District court ruling, which clarified that impacts evaluated under CEQA are limited to a project's impact on the environment, as opposed to the environment's impact on a project, which is referred to as CEQA in reverse. An example of CEQA in reverse would be declaring a significant impact due to existing traffic congestion and delays, which is not the project's impact on the environment, but rather the existing environmental condition within which the project will occur. Of course, vehicle trips generated by a project must be evaluated to analyze the project's impact on the environment, including the effects of project-generated traffic on the noise environment, on the air quality environment, and on transportation and safety. The comprehensive update to the CEQA guidelines resulted in modifications to the Appendix G checklist, which is relied upon to conduct initial studies and has been expanded over the years to cover 20 topic areas, ranging from aesthetics to wildfires. Both the energy and the wildfire topic areas were added to the checklist in 2018, and in the decade prior to that, the greenhouse gases and the tribal cultural resources topic areas were both added. A couple of major changes to the checklist that are particularly relevant to San Rafael is how aesthetics and transportation impacts are taken into consideration. For aesthetics, the updates clarify that impacts to the visual character or quality of the environment are to be considered relative to public views as opposed to individual views. And for projects that occur within urbanized areas, impacts are to be limited to potential conflicts with zoning and other regulation governing scenic quality. In practice, this means that within urban areas, compliance with setbacks, height limits, and where design review findings can be made, aesthetic impacts would be considered less than significant. Another major update that occurred is to how transportation impacts are evaluated, and it shifted the standard of review from the level of service metric to the vehicle miles traveled metric. The intent of this change is to prioritize infrastructure improvements that get people out of cars and into sustainable modes of transportation. It ensures that environmental impacts of traffic, such as noise, air pollution, and safety concerns, continue to be addressed while promoting infill development and public health through active transportation and achieving greenhouse gas emission reductions. Last year, the Bay Area Air Quality Management District published new thresholds of significance for greenhouse gases to address climate impacts. This shifted the previously relied upon bright line thresholds to a performance-based criteria, which are defined as projects that do not include natural gas appliances or plumbing, would not result in wasteful energy use, and would achieve a reduction in project-generated VMTs consistent with the California Climate Change Scoping Plan and complying with off-street electric vehicle requirements in accordance with the CalGreen Tier 2 standard. In practice, this means projects that are all electric and meet the other performance criteria would result in less than significant impacts to greenhouse gases. In addition to the substantive changes to the statute, there have been a number of procedural changes that have occurred in the past few years related to postings, communications, noticing, and filing requirements. As of January 1st of 2024, CEQA requires that notice of determinations and notice of exemptions must be filed with the county clerk and posted to the state clearinghouse, which is intended to enhance transparency in the CEQA notification process. All of this is to say that CEQA is a dynamic and ever-changing set of regulation. Let's talk for a minute about what CEQA is and what it is not.
So as Olivia mentioned a few minutes ago, CEQA is a law that was enacted with a goal of protecting the environment to the greatest extent possible from harm caused by development projects. CEQA is also an informational tool that is used to identify environmental impacts and mitigation measures to reduce or eliminate those impacts. CEQA provides a framework for decision-making bodies, such as the San Rafael City Council and Planning Commission, to weigh environmental consequences of a project with its benefits prior to making a decision to approve, conditionally approve, or deny a project. CEQA is also an opportunity for public participation. As we'll discuss later in this presentation, CEQA provides several opportunities for members of the public, organizations, and agencies to comment on projects and their potential environmental impacts. CEQA is not a way to automatically stop projects from being approved. As we discussed on the previous slide, CEQA informs decision-making, but does not have the power to approve or deny a land use development proposal. In the same vein, CEQA is not a standalone approval process, meaning approval, adoption, or certification of a CEQA document does not necessarily mean that a project will be approved. While CEQA requires mitigation measures that minimize or reduce environmental impacts to the greatest degree possible, CEQA does not guarantee that no changes to the environment will occur. Lastly, CEQA is not intended to be an obstacle to development. Though CEQA may add time and complexity to projects, it is not intended to unnecessarily slow or stop development. Rather, as we've mentioned several times, CEQA seeks to achieve responsible and sustainable development through informed decision-making, identification of mitigation measures, and public participation.
So when does CEQA apply? It applies to all activities that meet the CEQA definition of a project. A project under CEQA is defined as an activity which may cause either a direct physical change in the environment or a reasonably foreseeable indirect change. Under CEQA, a project is an activity directly undertaken by a public agency. For example, the city of San Rafael installing new sidewalks, carrying out improvements to public parks, or constructing a new fire station would qualify as a project. Another example would be adoption of an update to the general plan, such as the housing element or the safety and resilience element. A project is further defined as an activity that is supported by grants or loans, for example, the allocation of funds to construct an affordable housing project or to purchase new equipment like a fire engine. A project is also an activity that involves the issuance of a lease, a permit, a license, a certificate, or an entitlement, such as a design review permit or a conditional use permit issued by the city.
So once an activity is determined to meet the CEQA definition of a project, the lead agency is then tasked with reviewing the project under CEQA. The lead agency starts by determining whether streamlining provisions or exemptions may apply. While it is important to analyze environmental impacts of a project, the state legislature has established streamlining provisions and exemptions for projects that meet certain criteria. As shown here on the left hand of the slide, streamlining provisions are included in Articles 12 of the CEQA guidelines, and exemptions are provided in Articles 18 and 19. Both streamlining and exemptions have been established to increase efficiency and avoid preparation of repetitive environmental analyses. One example of a streamlining provision under CEQA is for affordable housing projects that provide housing for low-income households. In order to qualify for this streamlining opportunity, this type of project would have to meet several criteria, such as being located on a site that is less than 5 acres and within an incorporated city of a certain density and population. If a city meets all streamlining provisions, no further analysis under CEQA is required. CEQA also provides several statutory and categorical exemptions. Statutory exemptions are granted by the state legislature and apply regardless of the environmental impacts of a project, whereas categorical exemptions are classes of projects that have been determined by the state to be those that do not typically have substantial impacts on the environment. The primary difference between statutory and categorical exemptions is that statutory exemptions are absolute, meaning that if a project qualifies for a statutory exemption, CEQA absolutely does not apply. On the other hand, categorical exemptions are subject to various exceptions, such as if the project will result in an adverse impact to a historical resource. In the case of a categorical exemption, if an exception applies, the project is required to go through CEQA review regardless of the exemption's applicability. Examples of statutory exemptions include preparation and adoption of an urban water management plan, operation of family daycares, and Olympic Games. A common example of a categorical exemption is expansion of an existing single-family home, which would qualify for the existing facilities exemption. If a project does not qualify for streamlined review or exemption from CEQA, the lead agency can prepare an initial study to determine the level of review needed. The initial study may conclude that an addendum to a previously prepared EIR is appropriate if a proposed project will not result in new or more severe environmental impacts. For example, an addendum to the General Plan 2040 and Downtown Specific Plan EIR was prepared for the most recent housing element update. The initial study may also conclude that a project will have no impacts and a negative declaration would be prepared, such as with the Marin Sanitary Service rezoning and master use amendments. If a project may have impacts, but mitigation measures would reduce those impacts, a mitigated negative declaration would be prepared, such as with the Los Gamos apartments, as well as the Rotary Manor culvert replacement project. And last but not least, if the initial study concludes that a project will have significant impacts on the environment, an environmental impact report would be prepared. A few examples in San Rafael include the BioMarin project, as well as the General Plan 2040 and Downtown Specific Plan EIR.
So let's unpack the substantive and procedural requirements of an EIR by touching on required processes and procedures, the contents of draft and final documents, public comment opportunities, and the various roles and responsibilities. The process to initiate an EIR begins once a project is sufficiently defined, be it through the submittal of a development review application to the city or a city-led effort. If the project has the potential to result in potentially significant impacts, then a determination is made for an EIR to be prepared. An initial study may be prepared as part of the EIR process, but is not required. The EIR process formally kicks off through publication of a Notice of Preparation, or NOP. The NOP provides notice to the community, stakeholder, and agencies that the city is preparing an EIR, and it opens up a 30-day public comment period on the scope of topics and issues of concerns to be addressed in the EIR document. During the 30-day comment period on the NOP, a scoping meeting may be held to receive oral comments. The next step is to prepare the draft EIR, which can take several months to years, depending on the nature of the project and other factors. Once the draft EIR is available for review, a notice of availability is circulated to all interested parties and posted publicly, and it opens a 45-day public comment period on the contents of the EIR. Public meetings may be held to receive comments on the draft EIR, but are not required. What is required is for all comments received to be taken into consideration and responded to as part of the final EIR. The final EIR addresses comments raised, it provides clarification where needed, and any additional information. The final EIR must be made available to all public agencies that have commented on the draft EIR at least 10 days prior to its consideration for certification. If the city's decision-making body determines that the EIR is adequate, CEQA findings are made, and if necessary, a statement of overriding considerations is adopted, and the EIR is then certified.
So we'll go ahead and dive into the contents of a draft and final EIR, starting with the draft. So draft environmental impact report analyzes a proposed project's potential environmental consequences and is meant to provide analysis that is supported by data, studies, and technical analyses to help decision makers and the public understand the effects of a proposed project. To achieve this, the draft EIR must include specific contents, including a summary of the proposed action and its consequences, a clear and thorough project description, and a description of existing physical and regulatory conditions. The project description includes detailed information related to the location, boundaries, surrounding environment, characteristics, and objectives sought by the project, as well as a statement regarding the EIR's intended use. For example, the San Rafael General Plan EIR was used by the city to analyze impacts of general plan build-out prior to adopting the plan. In addition, the draft EIR includes a description of existing physical and regulatory conditions, which is used to establish the baseline and framework within which impacts are discussed and analyzed. The analysis, as I mentioned, relies on data, studies, and technical analyses to evaluate impacts of a project relative to established significance thresholds. For example, an EIR may rely on an air quality analysis to determine whether or not a project would result in air quality emissions that exceed thresholds established by the Bay Area Air Quality Management District. The EIR analyzes impacts across a variety of areas and documents significant impacts, including any cumulative impacts. Where impacts are identified, mitigation measures are established to avoid or reduce the impact, such as emission reduction or habitat preservation. The EIR is also required to include an analysis of a reasonable range of feasible alternatives, including a no project alternative. While not all alternatives need to be analyzed, the EIR should include a discussion of those that could feasibly attain project objectives. Going back to the primary intent of CEQA, the draft EIR ultimately aims to inform responsible project decisions that balance development with environmental protection. So following preparation and circulation of the draft EIR, the lead agency then prepares the final EIR. The contents of the final EIR include the draft EIR or any revisions to the draft EIR, a comprehensive response to comments received, and any other information the lead agency chooses to add. The responses to comments section of the final EIR includes comments received either verbatim or summarized, a list of the commenters, and the lead agency's response to environmental points raised.
Once a final EIR has been prepared, decision makers must decide if it satisfies CEQA requirements, and if so, may take action to certify the EIR. An EIR must be certified prior to making any decision on project entitlements. The EIR certification process requires that for each significant impact identified, one of 3 potential findings must be made. The first finding is that changes have been required and/or incorporated and avoid or substantially lessen the significant environmental effects. For example, a project may have a significant impact due to greenhouse gas emissions because the project had proposed inclusion of natural gas. However, mitigation measures are imposed that require all electric development. The second finding is that changes are within the responsibility and jurisdiction of another public agency and have been or should be adopted by that agency. The final finding is that specific economic, legal, social, technological, or other considerations make infeasible the mitigation measures or project alternatives identified. This finding is made for impacts that are significant and unavoidable, meaning that even with mitigation measures, impacts cannot be reduced to levels below significance. When this finding is made, it must be supported by a statement of overriding considerations, which holds that the unavoidable impacts are outweighed by the project's benefits. An example of this might be a project where vehicle miles traveled is exceeded, and mitigation requires that new residents receive public transit passes, but the use of those passes cannot be guaranteed to achieve a quantifiable reduction in VMTs. So the impact is determined to be significant and unavoidable, and a statement of overriding considerations would be needed in order to justify that the project benefits outweigh the project impacts. A key part of the EIR process is public comment and participation. There are multiple opportunities afforded to community members to provide both written and oral comments. When the city decides to prepare an EIR, the notice of preparation is released, which allows for a 30-day public comment period and typically a scoping meeting intended to inform the scope of topics to be covered. Then once the draft EIR is published, a 45-day public comment period commences. The EIR comment periods are not the time to express support or opposition to the project, but rather are to identify any concerns with the analysis contained within the environmental document. Additional public comments can be made during public hearings on the project, and other opportunities for public input may be provided through more informal meetings like community outreach efforts, neighborhood meetings, workshops, and study sessions. The role of the public in the EIR process is to provide input to decision makers on environmental considerations and concerns during the public review and comment periods. The role of the decision makers is to ensure that CEQA lead agency obligations have been fulfilled. CEQA defines the lead agency as the public agency with the principal responsibility for carrying out or approving a project. For activities within city limits, the city of San Rafael would be the lead agency. Lead agency responsibilities include ensuring that substantive and procedural requirements of CEQA are met, that environmental concerns raised by the public and stakeholders are adequately addressed in the CEQA analysis, and to navigate the balance between environmental protections and community goals and priorities. The lead agency may have the principal authority on a project activity, but other state agencies may also have permit authority or other obligations, and these agencies are referred to as responsible and trustee agencies.
So we'll go ahead and start with a discussion of responsible agencies under CEQA. So a responsible agency is a public entity that holds some level of discretionary authority over a specific part of a proposed project. While the lead agency oversees the entire project's environmental review, responsible agencies play a crucial role as it relates to their approval process. Responsible agencies are only responsible for mitigating or avoiding the direct or indirect environmental impacts of the project components that are under their control, and can propose or adopt feasible mitigation measures within their jurisdiction. To that end, responsible agencies must consider the CEQA document prepared by the lead agency and often rely on the environmental documents prepared in their approval role. Typically, the lead agency will identify responsible agencies early in the process and will engage in early consultation to identify potential areas of concern. A responsible agency may also submit comments and recommendations to the lead agency to suggest improvements to the document or to propose additional or refined mitigation measures or alternative project approaches. As with the lead agency, responsible agencies are required to reach their own informed conclusion about the project's environmental impacts prior to approving actions or activities that fall within their purview. A few examples of responsible agencies include the Bay Area Air Quality Management District, the California Department of Fish and Wildlife, the state and regional water quality control boards, the San Francisco Bay Conservation and Development Commission, and in Marin County, the Marin County Parks and Recreation Department. Similar to responsible agencies, trustee agencies are required to form their own independent conclusions about a project's environmental impacts on their trust resources. If a trustee agency also has permitting authority over a project, its role in the CEQA process would be that of the responsible agency. One common example of this would be the California Department of Fish and Wildlife. The primary responsibility of a trustee agency is to protect and manage specific natural resources entrusted to them, such as fish and wildlife managed by the California Department of Fish and Wildlife, state lands, which are managed by the State Lands Commission, state parks, which are managed by the State Department of Parks and Recreation, and university lands, which are managed by the University of California. Similar to responsible agencies, the lead agency will engage in early consultation with trustee agencies if impacts to trust resources may occur. If trust resources are affected by a project, the trustee agency is responsible for thoroughly reviewing environmental documents to assess potential impacts on the resources that are under their jurisdiction. Based on their expertise and knowledge of these specific resources, trustee agencies can provide the lead agency with comments and recommendations that may be included as additional mitigation measures, project modifications, or alternative approaches to minimize or avoid impacts on their trust resources.
We've covered quite a bit today. If you're wondering where to look for more information about any of the topics that we have touched on, there are numerous resources out there, and we've listed a few here. The State Governor's Office of Planning and Research provides environmental and land use planning resources, technical guidance and advisory, and hosts the CEQA.net web portal, which is a statewide database where local, regional, and state agencies post environmental documents and notices. The City of San Rafael's website provides information on environmental review for the general plan and the downtown precise plan, along with information on the various actions taken by the city as the general plan is updated. The final link here is for the Marin County Clerk, as CEQA notices are to be filed with the clerk's office. This link provides information about filing requirements, and all current CEQA filings countywide can be found as well. So that concludes our workshop today. We hope that the information provided has been helpful to demystify CEQA and help to understand CEQA's role in the city's planning process. Thanks for tuning in.